On October 5th, 2022, Professor Tom Meissner was finishing up class a little before 2 p.m. in the afternoon. We heard testimony that he was talking to Lozade Guzman, a student that was seeking out a little extra help to get up to speed on some of the course material and so forth. At that point, he didn't know that he was moments away from dying. He didn't know that the defendant was waiting to shoot him 11 times. He came out of that classroom and he headed down the hallway, and very quickly he was running for his life. Running for his life because this man opened fire on him. As you heard, he ran down the hallway, made that left as he was heading back to the office, 122, and he makes it into 122, and the shots don't stop. The defendant follows him as he goes into that room, and he continues to shoot into that room. You have evidence of those pictures of the bullets and so forth being recovered in that room. You have the testimony of Tim Corley and others that say that they're seeing him shoot into that room at the victim while he's on the ground. And while this is happening, shortly thereafter, Irma Santander, Kathy Baring, Lupe Romero, and Tim Corley are all there to try and deal with this absolutely terrifying incident that just unfolded in front of their own eyes.
I'm calling 911.
University 911.
I have a shot. Somebody got shot
Where at?
in Harshbarger Building, room 122, Tom Maddox.
Tom Maddox was shot?
Tom Meissner, I'm sorry. He's bleeding. He's got shot 3 times.
Room 122?
Yes, please hurry. Get the how we need an ambulance. He's been shot in the chest. He's bleeding.
Okay, was this related to another shooting sample?
Yes, Dervish. What is his name? Dervish, Murad Dervish.
In room 222?
Yes, please.
WC colleagues on?
He's in room 122.
Yeah, Hartford related.
What?
I'm going to try and transfer you to men so that they can give you instructions.
Yes.
Stay on the line.
Please hurry. Doctor, it's okay, Tom. Please call his wife. Please call.
911 was located.
We got shot. Our Tommy has got shot.
He needs instructions.
Now, we're going to spend a lot of time talking about this, but the defendant's been charged with a variety of crimes, as you know. The first crime that he's been charged with is that premeditated first-degree murder. That requires a few things. We're going to talk about it a little bit right now, but I'm going to walk you through how the evidence has proven beyond any reasonable doubt that he premeditated this crime. Now, as you see, premeditated murder requires that the defendant caused the death of another person. That's something that has been proven beyond any reasonable doubt. Mr. Mazurski, in his opening statement, said as much. They're not debating whether or not he killed him. Also, it requires that he intended or knew that he would cause the death of another person. And 3, that he acted with premeditation. Those second and third elements have been proven beyond any reasonable doubt. We're going to spend a lot of time talking about why that is and how the evidence supports that and should leave you firmly convinced. Now, this premeditation concept is something that we need to spend a little more time on, and we'll be doing that as we continue talking this afternoon. It requires a couple things. That he intended or knew that he would kill Dr. Meissner, and that after forming that intent or knowledge, he reflected on the decision before he actually killed him. And it's important to note, as the instruction that Judge Fell read you specifies, that the time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. Now, while the law suggests that you don't really need that much time and energy and evidence of premeditation in order for someone to premeditate a murder, we have that in abundance in this case. Now, that's not the only form of first-degree murder that he's been charged with. We also have this felony murder. And so what that is it's this concept that there are certain types of crimes that are so inherently dangerous that if somebody dies during the commission of that crime, it's a first-degree felony murder. And in this case, The crime that we're talking about is that burglary in the first degree. The idea of taking that loaded Ruger 9mm handgun into the Harshbarger building as classes are getting out and students are moving about and opening fire. That is a burglary in the first degree. And then additionally, for this felony murder, in the course of and in furtherance of that offense, this burglary in the first degree, causing the death of any person. That's exactly what he did. So burglary in the first degree, break it out a little bit more, that the defendant requires that the defendant entered or remained unlawfully in a non-residential structure. The Harshbarger building is a non-residential structure. The defendant did this with the intent to commit any theft or felony therein. He went there to kill Dr. Meissner. The evidence is going to become clear. It should already be. We're going to spend a lot of time talking about it. And at some time between the moment of entry through the flight from the scene, the defendant knowingly possessed a deadly weapon. Now, to this point, it's important to note that the defendant knows that he's not even allowed to be on campus, let alone confronting Dr. Meissner with a loaded firearm, essentially ambushing him.
In addition, I just want to reiterate to you about your contact with university officials. To continue the threatening type of behavior, additional charges can be added. If you're on university property, on university campus, trespassing charges apply as well. Those charges can be added. So that's just a caution to you, sir. In addition, I just want to reiterate to you.
And he tells us this. I mean, don't just take Lieutenant Keegan's word for it. He tells us that he knew that he was not supposed to be on campus, and he tells us that he knew he was not supposed to be contacting Tom at all.
Out of my job, he had had me tossed out of the school. So for all intents and purposes, I was out of his life. There was no right. I mean, he had me, just like you said, I'm not supposed to be on the campus. I'm not supposed to be contacting him at all. So for all.
So when you're back in the jury room and you're determining whether or not the state has proven whether or not this man entered or remained unlawfully in the Harshbarger building that day, not much thinking you're going to need to do based on his understanding of not even being allowed to be on campus, let alone that building.
You know, he had
Aggravated assault, the next charge that the defendant's facing. This requires proof that the defendant committed an assault and that the defendant intentionally, knowingly, or recklessly caused a physical injury to another person. It's aggravated by the fact that the defendant used a deadly weapon. Okay, so let's talk about this. We're talking about Tim Corley here. He testified that he was in the room, as we all know, room 122, and when he got grazed by that bullet. He has that injury on his leg. That is an aggravated assault. He received a physical injury by virtue of the defendant using a deadly weapon. Now, endangerment, there are 3 counts of endangerment. This relates to the 3 ladies that were also in the room that day. Had the good occasion to have the most terrifying and horrifying thing that somebody should ever have to see happen right before their own eyes. To someone that they cared about, somebody that was their co-worker and was an important person in their life. And that specifically requires that the defendant regarded a substantial risk that his conduct would cause imminent death, and that the defendant's conduct in fact did create a substantial risk of imminent death to those 3 ladies. When they testified during trial, they told you that, each of them individually, as they took their turns up on the stand, recounting the harrowing details of what happened that day. They each told you individually that, yes, I was concerned for my life. And how could you blame them? You're going to have pictures back in the jury room that show the bullet defects to the computer monitor, the gray stripe on the door, and so forth. This is relatively close quarters we're talking about here. With all these gunshots being fired into the room, that is the poster child for causing the sort of substantial risk of imminent death that the laws of this state create a crime, this crime. Now, really, when you go back to the jury room, there's going to be 2 big questions that you need to ask yourselves, and that's where we're going to spend the bulk of our time. And that is these 2. Does the evidence prove that this was a premeditated murder beyond a reasonable doubt? The answer's absolutely, and we're going to talk about that in great detail. Second question, has the defendant proven that he did not appreciate the wrongfulness of his crimes by clear and convincing evidence? Absolutely not. Let's take these one at a time, because these really are going to be the lodestar of your deliberations. The answers to these two questions are going to answer the two things that are, frankly, in controversy in this case. Whether or not this was a premeditated crime, and whether or not he appreciated the wrongfulness of what he did. Let's start with premeditation. And when we do this, when we talk about premeditation, it's important, I think, you may agree, to split out this evidence of premeditation to premeditation that's occurring before the crime occurred, evidence of premeditation that's occurring while the crime's occurring, and evidence of premeditation that's occurring after the crime occurred. So bear with me, that's going to be what we're going to do right now. So evidence of premeditation before the killing of Tom Meissner. Couple bucks doesn't really fucking matter at all, since I'm just going to use it to kill several people and then myself. That's pretty good evidence of intending to kill someone. Little did Tom and everyone else know he was going to make good on it.
Big wing.
That's my handle on our case.
Okay. And so you guys went back and forth on price.
Well, looks like we might have a little glitch, but 4816 to 4850, if you have occasion to listen to this back in the jury room, is the key moment that you're looking for. And if you could hear it now, you would hear that the defendant says, yeah, it's pretty self-explanatory. This, I'm going to kill several people than myself. That's pretty self-explanatory what I meant by that. Don't take my word for it, though, because you'll have that back in the jury room in 4816 and 4850 is what you're looking for. This is our first piece of evidence, chronologically, of the defendant intending to kill and forming a plan to kill Tom Meissner. But wait, there's more. Next, we have these horrible emails to Veda Kowalski. She was the first witness that we had testify. Seems like a million years ago now. But the first witness that we had testify in this trial states 166, 167. You'll have them back in the jury room. First one, you goddamn fucking piece of shit, trash department needs to fix your own terrible decisions. I'm not going to fix it or help you fix it. If you don't, I promise the consequences are going to be absolutely catastrophic. This is somebody that already has a view towards fire and brimstone in the Harshbarger building. Next, same morning, 2:26 in the morning, the defendant says, Mr. Goddamn asshole scumbag Meissner attacked me in the hallway and I defended myself and your office needs to do something about that. I don't think you have any clue who you're dealing with, but you're about to find out, and I really don't think you're going to like it. So, naturally, this sort of hateful emails, threats, gets the attention of the University of Arizona Police Department, and they head on out to his house. And the defendant lies about, what he may or may not have done.
So what is it again? It's a citation for what?
There's two charges for threats and intimidation, sir.
For threats
Yes, sir.
made by me, you're saying?
That's what the charges are for, yes, sir.
And they're misdemeanor threats?
They are, that's correct.
Well, I didn't make any threats to anyone, so I don't know what
Well,
that
that's something that
Again, video is not quite as clear as we'd like it to be, but you're looking at Exhibit 177 from 205 to 235.
So,
And then just moving forward on the timeline, chronologically, we have yet another solid piece of evidence that suggests this was a premeditated murder, well before the homicide actually happens. And of course, this is the now infamous email. I hope somebody blows your fucking head off. To Dr. Meissner, sent by Murad Dervish, May 28, 2022. Again, we're starting to see a pattern here. We're starting to accrue evidence of premeditation well before this actually goes down. But wait, there's more. So during Dr. Johnson's evaluation of the defendant, he said that the defendant brought up this Yom Kippur thing. He said that the defendant volunteered that. That was not something that Dr. Johnson threw out there. That was something that wasn't even on Dr. Johnson's radar. The defendant brought it up, and he said, you know, basically, it's the Jewish Day of Atonement, and that Tom would atone for his sins. That day was chosen for a reason. That was not a coincidence. That was no accident. Again, more evidence of premeditation prior to the killing of Tom Meissner. What else? So we have the seats that are removed from the van. We have the mattress that's purchased and loaded up in that van. Again, more evidence of premeditation here. He did it because, you know, if it isn't already clear, he had plans to not be in Tucson. You know, defense counsel has no burden other than the guilty except insane thing. They may get up in a few minutes and say that the defendant went to Harshbarger just to talk it out to Dr. Meissner. Just see if they could have some sort of understanding that they came to. That's belied by the fact that he loaded up his car as though he was just about to leave town. That fits much better with all the other evidence of premeditation that we have talked about and will talk about.
You know, I would have gone out of this city that I can't stand.
And you bought this van and took the seats out in order to be able to live in the van, right?
Right.
So what was the idea? You were going to go to San Diego and live in the van?
Right. Yeah. Yeah.
Okay.
Yeah, I bought like a mattress and put all my stuff in there.
And
Exhibit 214, you'll have the entire audio of the interview with Dr. Sullivan. That particular segment comes at the 1 hour, 14 minute, and 26-second mark. So we yet again still have more evidence of premeditation before we even get to the point where he's shooting that weapon repeatedly at Dr. Meissner.
Do you want some more water?
I felt so disrespected, I felt like I had to do something. Again, this is the formulation of that plan. He wasn't just going to let it go. Tom's death is an example of that. There's still more. Before, he's not even in the building yet. And there's still more evidence of premeditation. He buys that Ruger 9mm handgun, September 2022. He goes to the Harshbarger building on October 5th. He brings the gun with him. Very important piece of evidence. Brings the gun with him. He lingers around the building waiting for class to get out. And we know what sort of impact his mere presence in the building had on other folks that knew him and knew him well. Kayla McCauley, upon seeing the defendant, she goes straight to Dr. Whitaker's office. They turn off the lights, lock the door, hide under the desk, and call 911. They knew what the significance of him being in the building was.
911.
Hi, my name is Martha Whitaker. I'm in the Harshbarger building. There has been a report of someone who has been expelled who was in our building. His name is Murad Dervish.
And mind you, this is before any gun is displayed, any shots are fired, or the horrifying incidents that were about to unfold actually happened. That 911 call is happening before any of that. Now, intent inference. One of the instructions that you've been given is what's called intent inference, and it reads like this. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. So you might say, well, gee, Hotchkiss, why is it that we're using the behaviors that Martha Whitaker and Kayla McCauley are exhibiting as evidence of guilt against the defendant? The defendant didn't do that himself. Well, this is why. Common sense is why. You as jurors are allowed to employ common sense back in the jury room. Congratulations. If it wasn't clear, you may do that. Now, still talking about prior to the killing of Dr. Meissner. He sits in Dr. Meissner's classroom. He waits for Wilzabe Guzman to leave, and there's no talking between the two of them. Wilzabe Guzman testified that there was no talking before the shooting. She didn't hear any voices. She heard gunfire. And the defendant himself suggests that Tom never saw him and that there was no talking. Exhibit 214, 21 minutes, 12 seconds is what you're looking at here.
So let me just ask you, you waited, and you correct me if I'm wrong here, you waited for the student to leave. The student left. Meissner comes out and he sees you. You have some sort of interaction with him that we're not going to go into.
Well, I'm not sure why you say he saw me. I mean, you said it last week too. I'm not sure if...
Okay, that was my impression.
Your impression.
So you tell me, you tell me.
Yeah. Well, I mean, it's not... I mean, it's not really important who saw who first, or who said what first, or if there was anything said or it wasn't. You know what I mean? All that.
Okay.
Not, you know what I mean? Yeah.
Sure.
Yeah.
Well, thanks for the correction. I mean, that's just the way I guess I spoke.
Okay, yeah, that's fine.
So the defendant himself is disclaiming that Tom saw him before the shooting happened. And he's disclaiming that there was anything that was said before the shooting happened. Now, we're moving on to while he killed Dr. Meissner. Okay. He chases him down the hallway while shooting. He shoots him 11 times. You know, the firing of 11 shots and the sort of injuries that the forensic examiner, Dr. Winston, testified to is, in and of itself, evidence of premeditation. Of course it is. This was not a one-shot deal. This was 11 shots all over his body. He empties that magazine in the process. Now, Tom's own words are good evidence of premeditation while he's killing him. Fucker, I knew you were gonna. The last words that came out of Tom's life or his mouth before he lost his life were, fucker, I knew you were gonna. So again, this intent inference. You may use your common sense and that instruction to tell you that Tom knew that this guy was a ticking time bomb, and it was just a matter of time before he made good on it. His very last breath was used saying those words. Continuing, other evidence of premeditation while he's killing him. He shoots Tom while he's already on the ground in room 122. Tim Corley testified to this. Dr. Erin Ratcliffe testified to this. She described seeing the shooter shoot into 122 from just outside the door. And you'll have that floor plan back there. I think you recall. You've all been paying attention, taking good notes. Importantly, other evidence that shows premeditation while he killed Dr. Meissner. The victim's blood is found on the sole of his shoes. Okay? So if there's a suggestion that all of the shooting happened out in the hallway around the corner there, that's interesting because there's no blood over there. How did that blood that came back at 180 septillion to 1, that frequency rate that Ms. Hentz testified to, how did that get on the bottom of his shoes? It got on the bottom of his shoes because much like Mr. Corley testified to, much like Dr. Ratcliffe testified to, he was there at 122 shooting into the room. And also it's important that the autopsy results in Dr. Winston's testimony corroborate this. Corroborate the fact that there's this like coup de grace shooting while the victim is already on the ground. Let me tell you why. Dr. Winston detailed a whole bunch of findings, a whole bunch of shots during his examination and while he testified. There's 3 that stand out that are noteworthy. Okay, first one, up top. Entrance. Lateral right chest. Perforation. What did the bullet hit? The aorta. Trajectory. Front to back, left to right, upward. You may remember there was that moment towards the end of his testimony where I said, that upward trajectory, is that consistent with somebody shooting someone when they're already on the ground? He said yes. And that makes sense. Why else would the bullet be heading upward at the time that the shooting happens? Additionally, we have further evidence that further corroborates that with 12 and 13. We have 2 more upward trajectories. But what's noteworthy about this? They're in his lower extremities. They're in his shin and his calf. So again, how would he be in a position to be able to have an upward trajectory shot that entered in through his shin and his calf unless he was already on the ground and standing at his feet? Common sense here, folks. Now we switch to evidence of premeditation after he killed Dr. Meissner. His mom came in and testified and said that he told me in that voicemail, "I hope he dies. I hope he dies." That is evidence of premeditation after the fact. This was no mistake. This was no knee-jerk thing. This was him culminating a plan that had been kicking around in his head for a while. And he tells you this himself.
At least I fulfilled my mission.
He told Dr. Sullivan and Dr. Baker that revenge was his way of getting justice. Now, speaking of Dr. Sullivan, he reached some conclusions. You heard him testify. One of the really important things that you as jurors do is determine the credibility of witnesses. Okay? It's actually the most important thing that jurors do, is determining how much of each witness's testimony you think ought to be believed. That is a juror's role in a nutshell. And Dr. Sullivan, when he testified, came to some conclusions. When he did, he said that Mr. Dervish's murder of Dr. Meissner is characterized by deliberate, goal-directed behavior. The murder followed months of threatening communications from defendant to Dr. Meissner and other University of Arizona personnel. In the weeks leading up to the murder, Mr. Dervish made specific arrangements to procure firearms and ammunition, as well as a motor vehicle. Now, all of this evidence that I've just spoken about proves beyond any reasonable doubt that this man premeditated Tom's murder. So I ask you this: if everything that we've just discussed does not amount to premeditation, what does? This is premeditation, folks. The evidence has proven that beyond any doubt, let alone a reasonable doubt. But let's switch to wrongfulness. It's the second question that I said you all are going to want to have, spend some time talking about back in the jury room. Has the defendant met their burden of showing by clear and convincing evidence that he did not appreciate the wrongfulness of what he did? Guilty except insane. This is the instruction that Judge Fell provided you. It reads like this: the defendant is guilty except insane if, at the time of the crime, the defendant was afflicted with a mental disease or defect of such severity that the defendant did not know that the criminal act was wrong. The defendant, not the state, but the defendant must prove guilty except insane by clear and convincing evidence. So what does that mean? That means that it's highly probable that the defendant was insane. Highly probable that he did not understand that what he did was wrong. Now, the instruction continues. A mental disease or defect does not include disorders that result from acute voluntary intoxication or withdrawal from alcohol or drugs, character defects, psychosexual disorders, or impulse control disorders. Additionally, conditions that do not constitute insanity include, but are not limited to, momentary, temporary conditions arising from the pressure of the circumstances, or passion growing out of anger, jealousy, revenge, or hatred. Now, let's talk through some of this evidence that shows he appreciated the wrongfulness of what he did. So the defendant finishes shooting, and he immediately runs out of the building. The testimony of Tim Corley and others establishes this. He goes straight back to his van, and he starts aggressively driving through campus, trying to get away from the scene of his crime. He later told doctors that he never thought he'd make it off campus. That is evidence of someone that knows the clock is ticking. I've got to go. That is the words of someone that appreciates the wrongfulness of what they did. And as luck would have it, there was actually that dash cam snip where his van was captured fleeing the scene. They didn't know that that's how he got there at the time, but as luck would have it, he's fleeing the scene here. There's that other 911 caller that you heard from that reports that aggressive driving, the honking, and the fact that he was driving into the lane for oncoming traffic. That's how hell-bent he was on getting off of campus and getting out of there. that he was going into the lane for oncoming traffic. Now, of course, we know where he goes. He heads up I-10, heads west on I-8, then he makes that turn and heads south to the border. Now, let's talk about that. So he starts driving toward California, he changes course, then he heads south on 85 towards Mexico. Trooper Enriquez, who you heard from, testifies that he attempts that traffic stop. Defendant pulls over for a few moments, then he takes off again. Federal, state, and local law enforcement personnel pursue the defendant as he continues heading south. Defendant does not stop willingly. Trooper Enriquez has to use that pit maneuver to get him to stop. And one thing that I haven't said so far, but I think is really important, that is in the instructions that Judge Feld provided you, is that you don't examine and consider each of these pieces of evidence individually in a vacuum. Perhaps the second most important thing that a jury does, besides determining the credibility of witnesses, is view the evidence in light of all the other evidence, and in light of reason, common sense, and experience. So these things are not happening in a vacuum. These things are not coincidentally strewn together for some reason. There's a very good reason for why they're happening, all at the same time. It's because this man knows exactly what he's doing was wrong. So the defendant himself remembers and discusses details of the murder, including the moments while he is shooting.
Corley in the leg, and he kind of went down. He kind of bent down very fast, and I felt like he may be going for a gun or something. And that's how I came to run out of because I knew I didn't have any bullets left.
So another instruction that you've gotten is this wrongfulness instruction. Knowledge that the act was wrong, as the phrase is used in these instructions, means knowledge that the act was wrong according to generally accepted moral standards of the community, and not the defendant's own individual moral standards, which makes sense. It makes sense that we would have a community standard for whether or not somebody appreciates the wrongfulness of what they did, rather than an individual's own moral standard, because then anyone could be guilty of second sin. Just say so. You are. Congrats. Importantly, knowledge that an act is forbidden by law will permit the inference that the act is wrong according to the generally accepted moral standards of the community. So you as jurors may infer that if this defendant knew that what he did was illegal, that is tantamount to him knowing that it violates the moral standards of the community, and is another piece of evidence that can be used in determining that he appreciated the wrongfulness of what he did. And that's exactly what happened, and he tells us this. Again, more evidence showing he appreciated the wrongfulness of what he did. There's a lot of evidence against him. Is there a death penalty in Arizona? He's aware of the fact that he broke the law.
One more thing, you said to them, there's a lot of evidence against me, right? And then you asked, is there a death penalty in Arizona? So clearly, if you're saying there's a lot of evidence against me, is there a death penalty in Arizona? You're aware of the fact that you broke the law.
Yeah.
Okay.
Now, but wait, there's more. He says, as we know in the Sergeant Sultan video, which you'll have back in the jury room, Stakes 180, he says, hopefully I get out before I die.
I'll get out before I die. I'm trying to kill myself, but I can bring myself to do it. I'm going to shoot myself in the head.
We're not done yet. He even says it's actually one of the last things that's on the video of Sergeant Sultan's body cam that I even know better. He knew that he knows better than to do what he did. Again, another great piece of evidence that suggests he appreciated the wrongfulness of what he did.
Not having a job is a deal breaker. I could have used my savings, I guess. I felt like I was like disgraced. So. It's like I didn't know better too. I didn't know it's
just male egos? I don't think so. I don't think that's what's going on here. Now, one thing that's important to note is that what the defendant said to Sergeant Sultan is important. But what he didn't say to Sergeant Sultan is also important in other ways. So, he never says that he went to campus to talk to Tom. That's not part of that original statement when he's there at the police station. He doesn't say that. That's something that comes up later. He never says that he doesn't remember the shooting, or that he was psychotic, or that he had a mental health crisis, or any of that. That's not something that comes up till later. Now, Dr. Johnson, another piece of evidence here that suggests this defendant appreciated the wrongfulness of what he did, he concludes that he's not guilty except insane. And he reasons that he understood the wrongfulness at the time of the murder, despite being depressed and anxious. The defendant was not suffering from a psychiatric illness to the degree that it affected his ability to understand wrongfulness at the time of the murder. And he provides in his report, this is not exhaustive based on what else we've discussed, but he provides some of the specific pieces of evidence that leads him to conclude, as a psychiatrist that has done all manner of guilty except insane evaluations, that the defendant appreciated the wrongfulness of what he did. He quickly escaped from the scene. He was stopped by police while driving toward Mexico. He refused to stop when police were behind him with lights and sirens, and that pit maneuver was required. He admitted knowing that he was being followed by the police, and he made statements about going to prison for what he'd done. He appreciated the legal ramifications of what he'd done. Now, again, Dr. Sullivan, Mr. Dervish's claim that his awareness of the wrongfulness was absent during the actual offense, but rapidly reappeared immediately following the shooting, is quite fantastic and fails to comport with known mechanisms of consciousness, awareness, and psychological development. So folks, I'm almost done here, but I'll leave you with the two questions that I left you with a little bit ago. Does the evidence prove that this was a premeditated murder beyond a reasonable doubt? The answer is absolutely, based on all the evidence that you've heard throughout the course of this trial. Has the defendant established, by clear and convincing evidence, that he did not appreciate the wrongfulness of what he did? Absolutely not. That is the evidence in this case, folks. That is the evidence that shows beyond any reasonable doubt that this defendant is guilty of all of the charges that he's been indicted for, and he's not guilty except insane. He's just guilty. In a few minutes, you're going to go back to a jury room, pick a foreperson, and start talking about the evidence. And when you do that, there's only one verdict that is supported by the evidence, and that's to hold this man accountable for the horrific murder of Tom Meitzner and find him guilty as charged.